and get that person in court. Of course, that cuts off our ability to represent them under the contract. And so I just wanted to kind of get people starting to think about that. Maybe next time we can talk about best ways to approach that with the landlord's attorney. I definitely think that we should be mindful about not letting it get out as common knowledge that a landlord's attorney, that the landlord's bar can just get rid of us simply by filing a notice or serving a notice of petition. So yeah, I just wanted to put that out there, plant that seed, and we'll talk more about it next week when we talk about litigation. Okay, so getting back to the form lease, we left off at paragraph 4, talking about repairs. Okay, so we're still on the first page. This is the section that defines and apportions the responsibilities for the repairs to the property throughout the lease term. So it's going to tell you what the landlord is responsible for, what the tenant is responsible for, and some extras down here. In this section, again, just to remind you, we're going through the form lease just to make sure we hit all of the relevant portions of the commercial lease, but we're going to be reading this in tandem, the portion of the paragraph of the form lease together with whatever relevant portion talks about it in the rider as well. So just because I say paragraph 4 repairs here, doesn't mean you're only necessarily looking at the paragraph 4 in the form lease. You're also looking at whatever repair sections are in the rider. And when I'm looking at those, I want to ensure that it's the landlord's obligation to repair and maintain all of the structural defects, all of the building-wide services and systems. I'm talking about the HVAC, the elevator, the common areas, the fire sprinklers, the building plumbing, all of the things that service more than one unit in the apartment or the service or in the commercial space, or service common elements of the commercial building, should be the responsibility of the landlord, and any liability should fall on the landlord with respect to repairs that need to be made on those areas of the building. So make sure to delineate when you read through the sections covering repairs. Make sure that you have a clear picture in your mind of this physically, the space, and who's responsible for what within that space. You should try to negotiate a rent abatement provision for any period of time where the tenant is unable to use any portion of the premises, the leased premises, that's due to a condition that the landlord is required to repair. So for example, I spoke with a commercial tenant a few months ago who has a restaurant on the first floor of a building that has residential units above it. The landlord came in the middle of December and said that there's a gas leak, immediately vacated the restaurant for 2 weeks and said, we have to fix it, it's unsafe. And the tenant had to move out and just lost 2 weeks worth of business. The lease in that case should provide that where it's the landlord's obligation to fix the gas line that services the whole building, that any interruption in the business as a result of that repair should be abated. That the rent should be abated, or that there should be a set off on rent, or should be some kind of accommodation for the tenant in that kind of a circumstance.
Question about that too. So I think it's a little bit of a clear situation where the restaurant can't be used at all. What happens when there's some repairs required by the landlord? It doesn't necessarily mean the tenant can't use the space at all. It just somewhat inhibits their ability to conduct business. And how do you deal with that situation and implement it together?
So typically these kinds of provisions will include a proportional rent abatement language that'll say up to that the rent will be abated proportionally up to the tenant's full inability to use the entire space. So that's kind of vague and nebulous. You can't really foresee every single instance of what's going to happen, and there may be some dispute as to whether you were 40% or 50% unable to use that space. But typically, that's what kind of a provision is in there. This provision, I think it may be actually in the. It's not in the form lease, but typically the landlord's rider will include a proportional rent abatement up to and including a full rent abatement, or a full technically constructive eviction if it gets to that point. If the landlord goes and files a non-payment proceeding for a period of time that you think you were the rent should have been abated because of your inability to use it, that defense that you would use would be partial or full constructive eviction. So that would be contractual under the lease if you have that in there, that the rent should have been abated for that period of time. And then regardless of your success with negotiating a rent abatement provision, I think you should advise your client to speak with their insurance broker about business interruption insurance, because in the instance that I discussed about the restaurant owner, she did file a claim with her business interruption insurance. I don't know what the result of that was, but typically if you have that kind of coverage, then an incident like that would be covered for any losses that you incur when you can't operate your business.
Two questions. Do you, for, people are always afraid to make claims to their insurance for fear the premiums are gonna go up. So have you seen in practice, like if it's 1 or 2 days of lost revenue, maybe you eat it, but if it's like 2 weeks and it's a functioning restaurant, then that would certainly rise to the occasion of making a claim. Like, have you seen, because I could see somebody saying, well, if I report it, what's gonna be the impact on my coverage?
Right. I don't know enough about that. That would be a good question for an insurance broker. But I know that when a tenant is typically buying this policy, they're buying it for the term of the lease. So potentially you're buying a 5-year or 10-year insurance term. And so I don't believe that they can just increase the rent based upon claim activity throughout, maybe insulated that way. But that would be, I would mark that as a good question for an insurance professional.
And for the partial rent abatement, if it's like, it's one thing if it's like, a quarter of your restaurant you can't use because of repairing a leak, and so then there's like a square footage proportionality to it. But if it's something like the gas situation, and let's say it's summer, so they could do still food service without gas to a limited degree, like, do you think it would be reasonable to try to ask for, like, my regular weekly revenue is X, and because of the drop in, the ability to serve full food, I'm making this, like, revenue difference? Like, how do you think the argument would be when it's not really like a square footage partial impact, but it's more just kind of a revenue impact?
Normally it's drafted as a space consideration. And I see where that might come up. So in this instance, she was completely barred from entering the property. So that's a really bright line. That's a clear case. Where you're saying that, the landlord can come back and say, well, you were still able to fully operate your business.
Right.
So that would be the counter argument. So then, I could potentially see some vaguer language, rather than just based upon square footage, inability to use square footage. There was actually an interesting issue with this particular client with the restaurant, where after they completed all of the renovations, they actually had to put up some additional equipment and put up another wall in the bathroom of the restaurant, and so they actually lost some space in the bathroom due to these repairs. And so there was a question about continuing rent abatement for the loss of square footage. So I could see, we could definitely, I could see some language going in there, softening it a little bit so that you're not just talking about loss of square footage, but actually about loss of revenue.
On that note, sorry, I'm going on that point. So our partner, West Bronx Community Clergy Coalition, had mentioned that one of the problems that they were having with businesses on Jerome was the lack of heat. So the businesses were still operating, but in a miserable condition because they had no heat for years. So that's harder for them to even calculate what their revenue loss would be, and then you were still using the space, but just not to the extent that they not having the things that they should have had. So in that situation,
that's in that gray area. I mean, I gave you like the best case where the tenant was just like completely barred from even entering her own business. She just couldn't use it at all. The heat, if it's a building-wide service that the landlord has to provide, and it's interrupting your use of the building and the operation of your business, it would fall under most repair provisions. And I would make sure that the provisions that the landlord is offering are expansive enough to cover that kind of a situation as well. It gets a little bit dicey, and so the landlord might say, oh yeah, it's cold, but you can still operate your business. I'm always looking toward litigation. Like if that kind of a dispute ends up in litigation, if you withhold rent and they file a non-payment, and then you have a defense of repair, partial constructive eviction, that can get kind of dicey. A lot will really depend upon the judge that you get. But there is an argument to be made there. I don't know what the language would necessarily be to kind of solidify that to avoid litigation, or if the landlord would even go for it. But kind of softening the language away from a square footage inquiry or to just square footage use of the premises is definitely helpful. So, yeah.
Structural and building repairs. How specific would you recommend the language be code repairs?
About the structural repairs?
Yeah, like would you suggest like if you were a landlord responsible for repairing X, Y, Z, as well as any other structural or building repairs, or what does that typically look like?
You could if there's some interesting features of the building that are unique to that building. But typically, you just if you specify, even the form language I think specifies the landlord is responsible for external repairs for the facade of the building, for anything on the roof or in common areas. That's usually enough to delineate what is and what isn't the tenant's responsibility. The tenant should only be responsible for what services the tenant's space and within the tenant's own personal space that nobody else, no other tenants or the landlord has access to. And typically the language that's here in the form lease is enough to make that delineation, unless there's some kind of really unique feature of the building. If there's some kind of like semi-public-private space, some shared space, then maybe you might want to make a diagram or some more specific descriptions. Moving on to paragraph 6, talking about the requirements of law. Generally, this requires the tenant to comply with all laws, rules, regulations related to the premises. It's just a blanket requirement that the tenant be good. So here, I want to ensure that the tenant is not going to be responsible for undertaking any structural or capital improvements in order to comply with any law. So specifically, I'm talking about something like ADA access compliance. It's absolutely necessary. Every building should be ADA compliant. That's required to be, but that should not be the cost of the tenant, especially where it could be potentially a huge capital cost, permitting costs, construction costs. That's something that's permanent for the building that the landlord should be required to do. You should also ensure that the tenant is otherwise only responsible for the premises complying with the lease premises complying with laws, rules, and regulations, and not for any violations that are issued for any other parts of the building, similar to the repairs provision that we just talked about.
Sorry, I have another question now. So what if, based on a case diagram, if the tenant has a use that would require, so in this example, the tenant wanted to build a partial second floor, and the cost of making that ADA compliant was very high, and so the landlord was kind of like, I'm not willing to bear that cost because that's unique to your use of the space, and the space as such is ADA compliant without your second floor. So what do you have your thoughts on like how to address or anticipate that kind of like disagreement that's about like the tenant being able to use the space in which they want to use the space and any sort of structural investment will remain in the space, but like the landlord's position is not something that needs to.
So the second floor didn't exist at all yet?
Correct. Yeah.
Okay.
Or it was, it was partially constructed, so then they wanted both to add an additional portion and make the portion.
And it was vacant.
And it was vacant at the time.
Yeah, so I would say here, landlord, I'm helping you, invest in your property and build up your property. When I'm gone, you're going to have a second floor to your building that you can rent out. It's going to be all ready to go, turnkey with ADA compliance to any tenant you want. That would be my leverage. That would be my argument. At the very least, you could ask for free rent, maybe to offset some of the cost of the ADA compliance. Since you're taking on more space in your lease, it's kind of an additional. Maybe a separate lease that you can, a wholly separate lease that you can renegotiate all of these terms, or if it's amendment to the lease, adding some more space, you can definitely open up a lot of these terms and renegotiate them again for that portion of the new portion of the premises.
Example, if the client had known in advance that was like their plan, is that capacity that should have been integrated in the original lease agreement?
Absolutely, yeah. The tenant should always be aware of kind of the costs of expanding or conforming a space to their use, including very expensive construction, capital improvements like ADA compliance. I think it would be, I would just make the argument that it's a net benefit for the landlord to have some extra space built out that's ADA compliant and ready to go for another tenant later on down the road. It's an investment in the building that the tenant is helping to make, in partnership. So try to make kind of a partnership argument to the landlord and see, let's go in on this together. It also depends on how long the lease is. If you're only in there for 5 years, don't know if it's necessarily the best use of funds for the tenant to kind of help the landlord build out their own space. If this is a longer term lease, potentially you have some more leverage as well. It's kind of more of a partnership with the landlord.
But I think that if the build out is kind of unique to the use of that tenant, so for instance, I've done a lot of healthcare center commercial leasing, and a lot of their build out is for ADA compliance and so on, but it's kind of unique to their health usage. And like you can make an argument that you'll be able to lease this out to other healthcare providers, and the investments are really helping the value of the building. But I think that the landlord has a strong counter that, like, look, this is your unique use, and I'm permitting you to do that, but I'm not going to underwrite it. Yeah. So I mean, I think it does go into like the initial bargaining relief, and you get, you know, you negotiate it. But I think in that one, the landlord has a good counter argument. Not to say we don't advocate, but if like the building is ADA compliant for the base use, and you're kind of adding to it for your own use, I think it's gonna we advocate, but I don't know if you're in that negotiation. Unless it's like, you know, any business in that space is gonna benefit from like the internal elevator connecting to floors or something.
All right.
It's not successful.
Yeah, I was like, it's a hard one. Don't feel bad.
So skipping ahead to paragraph 8, I realize that's actually where we left off, so we redid a little bit. Apologies for that. Talking about the tenant's liability insurance coverage. So we initially already talked about the types of insurance coverage that are typically required by the landlord, commercial general liability, CGL coverage, property damage, as well as some additional coverage that you might ask your tenant to talk with their insurance broker about, specific to the business. If it's liquor license coverage, I recommend at this point all tenants look into flood insurance, regardless of where in New York City they are, or for reasons that are apparent. And when we're talking about property loss and damage coverage, you should ensure when you're actually going to see, you're going to ask for the tenant to provide you with the certificates of coverage once they've actually gone through and spoken with their insurance broker and actually purchased whatever products they have agreed to. And when you look at that insurance certificate, there's certain items that need to be on there. And if it complies, then it's going to serve as proof of coverage to the landlord. The landlord will accept an insurance certificate as proof of coverage at the initiation of the lease. I'll show on the next slide an example of one. We'll go through it together. But first, I just want to go through what should be on it. The tenant, like I said, should be prepared to show proof of coverage, insurance coverage at the initiation of the lease term. And you should counsel client, in addition to getting this one-page certificate of liability insurance, you should also counsel them to obtain from their insurance broker or the insurance company directly a full copy of the policy for its own files, because the certificate of liability insurance coverage is just a summary. It's not always correct. It's not always complete. And so the full packet, the full binder of insurance coverage is what they should at least have on file, so that if and when there is an issue, they're not scrambling for that documentation. You should also ensure that the client understands all of the required insurance coverage that's required under the lease, and that all that coverage must be effective from the commencement of the lease term throughout the entire lease without any lapse. So I'm going to highlight that again, because I actually litigated many cases in which the tenant's sole default of the lease was a lapse in insurance coverage during their lease term. And it doesn't matter if it's a day, if it's an hour, if it's a second. That is an incurable lease default pursuant to the appellate division case law. That is enough to get a tenant out for, it's basically no defense. And so I have a case citation here. Make sure that the tenant knows that the coverage must be continuous throughout the entire lease term. Here, do you guys have a copy of this? Is this in the material? Yeah. Okay. So just quickly running through what it looks like, just in case anybody hasn't actually seen it before. Up at the top right, you see a date. That's simply the date of the document. That's not the effective date. This date is not really relevant at all, so don't let that be your guide. Over on the left side, you see the producer. That's the insurance company that's issuing the insurance coverage. Under that is the insured. You should make sure that this entity in this box matches the entity that's signing the lease. If the tenant is signing as a corporation, it should be the corporation that's insured. If it's the individual signing as tenant, then it should be the individual here. The address here should be the business address of the lease premises. Down below, you see the different kinds of coverage that are included on this sample policy. So you see the general liability, that's CGL, commercial general liability coverage. You see the policy number next to it and the effective dates, policy effective and policy expiration dates. These are the important key dates. So make sure that the policy effective date is on or before the commencement of the lease term. If the policy expiration date is before the expiration of the lease term, make sure that the client diaries a month, 6 months out from that date to call back their insurance broker and extend their lease, their insurance coverage policy. And next to that, you see the limits. So the limits are something that are going to be dictated under the lease as well. There'll be typically limits for each occurrence, for damage, and for aggregate, as well as down below you'll see, sometimes you'll see umbrella and excess liability coverage as well. So you'll go through and do your best to just ensure that the requirements under the lease are all accounted for here on this liability certificate of liability insurance. One other thing I want to draw your attention to, all the way in the bottom left, there's a certificate holder box. That is typically where the landlord is included as an additional insured. The landlords love to have themselves as an additional insured somewhere on this certificate of liability insurance. Usually that means that the landlord is able to collect insurance proceeds for certain types of insurance claims. And they're definitely going to be looking for their name somewhere on the certificate. That's where it'll be. So it'll actually say additional insured : and then the name of the landlord, which should conform to the name of the landlord that signed the lease. All right. So in addition to this certificate of liability insurance, to the extent
on this cert, also I usually try to get, of course, the lease premises accurately described in the description of operations, so that, you know, a business might have more than one location, so you want it to specify the lease premises. And then if you can negotiate with your insurer so that they provide at least 30 days notice of an expiration, which is ideal, rather than 5 days, just to give the business time to renew and line up their ducks. If you have done that in your policy, the little cancellation box should be edited to reflect that 30-day prior notice.
Right.
And you'll see that I usually actually edited in the PDF by the insurance broker in that little cancellation box on the bottom right. And then disability insurance, you know, employers with employees often have to have workers' comp and disability. Disability is usually a different, it's not even a word cert, it's like a letter that confirms coverage. So that might be not listed here, but on a separate letter, and that's normal.
Yeah, this is this that we've just described, Jesse and I, is an ideal insurance certificate. I think insurance brokers are very stubborn in general about deviating from their typical forms, and as we discussed last time, insurance language and legal law language kind of don't overlap all the time. So if you have a provision in a lease that the insurance broker may not have language for, they may be very reluctant to kind of include it in there. So just do your best here and know that to the extent that we have kind of archaic, formalistic policies in the legal world, so does the insurance world. And so we're kind of working kind of against each other in some ways to produce this document.
And I'll email after this meeting a list of, we have 2 brokers that a lot of our clients use, who are really kind of nice people, and they're not over-insuring people. And they're willing to work with small startups, nonprofit businesses, and kind of do planning for the coverage. and also to accountants that a lot of our clients use. And if anybody else has others, I think it'd be great for us to have like an internal list, because often our clients don't have insurance yet. So what I typically do is, I'd love to have like, I have 2 that I have had good experience with. If we could make that 3 or 4, all the better. And I always say in my email to them, shop around, meet with at least 2, if not more, see who you have nice chemistry with, and be very clear on fees. So it's not like we are recommending, a private professional as a nonprofit, but that we're just kind of giving choices. Because frankly, there's a lot of brokers who also don't know what the hell they're doing, and also accountants. And then you have people coming in and you're like, you're under default of your lease, and why didn't, you tried and it got messed up out of your hands. So I do think that getting a good insurance broker is kind of key.
Yeah, this is very important, because it's any lapse here is an incurable default. Not just the lapse in cover in timing of the coverage, but also in limits or kinds of coverage. It's pretty stringent, and it can get your client kicked out if it's not completely in compliance. So, tenant's liability insurance, the indemnity portion of paragraph 8. The tenant's indemnity of the landlord should exclude damages that are incurred as a result of the landlord's own actions or their negligence, or a breach of the landlord's duties or obligations under the lease. The tenant's indemnity should be limited to the actual damages that are incurred by the landlord, and they should include consequential and special damages. The landlord should be required to seek coverage under its own applicable insurance policies before looking to the tenant or the tenant's insurance. That's a pretty standard provision. And the landlord may be required, just so that you know, if the property is mortgaged, and you can find out whether that's true on ACRIS, then the landlord may be required to keep a standalone insurance policy under its mortgage, even if there's no such requirement under the lease. So just because the landlord the landlord wants you to cover everything under the sun, doesn't mean it doesn't have its own insurance policy to fall back on in the event that there's a loss. Speaking of losses, in paragraph 9, we're going to be talking about destruction, fire, and other casualty. Yeah.
In reality, I mean, definitely we'll start with trying to limit tenant to actual damages incurred by landlord, and exclude consequential and special damages claims by landlord. But I feel like if we do that, if they haven't got that in their rider and we're just making it mutual, they'll immediately then try to limit their exposure by excluding consequential and special damages caused by tenant.
Right.
So like, I would usually say let's agree to mutual rather than giving up on it. What do you think?
I think that's a good way that's somewhere good to land on in the end. You should also have an idea of whether or not the landlord has their own insurance. If you can get your hands on that policy and see what kind of coverage they have, that'll give you a better picture of how you should go about negotiating it. Because you can imagine a hypothetical loss of $1 million and see how that's going to pan out, if it's covered under the landlord's insurance, if it's covered under your insurance, where any excess would go under any given set of language in the lease. So I think this is really fact specific, and you'll be better off with a landlord that's separately insured under a mortgage requirement or otherwise. I get the impression that landlords typically don't carry their own insurance policy unless they're required to by their mortgage banks, because they have very onerous requirements on their tenants to begin with. So that's definitely something that goes into the equation when you're negotiating this. But I agree, it should be mutual. To the extent that there's anything lopsided in the landlord's rider, not just here in the insurance provision, you should try to get it a little bit more mutual. We'll talk about that a little more when we talk about attorney's fees. Paragraph 9, it sets forth the obligations of the parties in the event that there's damage to the premises and that there's an inability to use the leased premises. So again, this is dovetailing back with the abatement provisions that we were talking about previously with the landlord's repairs. Some quick negotiation considerations are to seek proportional rent abatement for any portion of the premises that's inaccessible because the tenant can't reasonably use it for its own business when there's an interruption. We can also dovetail this back with business interruption insurance, which is a good thing for the tenant to look into with their broker. And I would also, in the negotiation phase of this type of provision, I would try to seek the tenant's right to terminate the lease in the event that there's a full or partial constructive eviction as a result of a loss that lasts over a certain period of time. So let's say 6 months or 6 or 8 months, depending on how heavily it will hit the landlord's business and bottom line. Or in the event that the loss casualty occurs within a certain period of time within the end of the lease term. So if within the last 6 months of the lease term there's a fire that completely decimates half of the building and the tenant was already planning on not extending the lease or moving out anyway, then I would try to negotiate an opportunity for the tenant to be able to unilaterally terminate the remainder of the lease term at that point and be able to just cut its losses and move on. Assignment, mortgage, etc. This is a fairly contentious provision. So a good assignment sublet provision for our clients are going to allow them the flexibility to exit the space due to economic conditions or other conditions before their lease term ends. So just a little bit of vocabulary. A sublease is where our client enters into a sublease agreement with another entity, another tenant, who becomes the subtenant. So the tenant becomes the sub-landlord and collects rent from the subtenant pursuant to that sublease, and the tenant is still obligated under the prime lease to its landlord. So there's still all these obligations flowing throughout the chain. An assignment is where the tenant assigns its rights in the premises under the lease to an assignee, and the assignee pays rent directly to the landlord. So the assignee is stepping into the shoes of the tenant under the existing lease that you have. They're basically just substituting the name. And under that kind of an arrangement, you should know that our client, the tenant, is still obligated under the prime lease to the landlord. They're basically just adding another pocket to get the obligations done under the lease. A recapture provision is a provision that allows the landlord to retake possession of the premises, and it releases the tenant from continuing liability under the lease. In the instances where I've seen a recapture provision, it's where the landlord wants the ability to recapture the space where the tenant is proposing a subtenant or proposing an assignment. And the landlord may be considering the assignment or the sublease and says, no, you know what, I'd rather just take the lease back. And so that kind of a provision should, of course, have complete exoneration of liability, continuing liability for the tenant. If the landlord takes the lease back, the tenant should no longer be responsible monetarily or non-monetarily for anything moving forward, of course. It's essentially an early termination provision. As far as the landlord's concerns regarding this provision, the landlord wants to ensure that its tenant has been vetted. Whoever is actually in the premises is creditworthy and is responsible, will take care of the premises, and it wants to limit the tenant's ability to hand off possession or the lease obligation to strangers or to change the internal ownership of the tenant. So if your tenant is a corporation, the landlord may want to have any kind of change in the stock ownership of the tenant be considered an assignment that would require the landlord's prior written authorization. And that's something that we can talk about with negotiation considerations and terms. The landlord's going to want a specific consent paragraph where if the tenant wants to sublet or assign, then they're going to have to seek the landlord's express written consent ahead of time. That's pretty standard. You should seek reasonable criteria. You should try to get the landlord to agree to consent to a sublease or an assignment, generally where the subtenant or the assignee is equally creditworthy, they have equal revenue based upon the documentary evidence that you'll show to the landlord, and that the consent from the landlord should not be unreasonably withheld, delayed, or conditioned. Sometimes a landlord will try to get out some administrative fees for review of financial documents or for attorney review. To the extent that the landlord wants these kinds of administrative fees in connection with a sublet or an assignment, you should try to cap them. See if you can say that, yeah, you can get your fees for considering my subtenant, but let's cap it at $1,000 per request. That's not unreasonable. For the change in control of the tenant corporation or the tenant entity, the landlord may see a change in the internal control of the tenant's business as a de facto assignment. So you'll try to allow the tenant to change up to 50% of ownership in the business without having to get the landlord's consent, or essentially without having it constitute an assignment. This will come up when it's a family business and they kind of loosey-goosey transfer ownership or membership interest in there. You don't want that to be a formal assignment that you're going to have to get landlord's consent for and pay administrative fees for. You want to be able to have that flexibility. And to the extent that there's a personal guarantee in place under your client's lease, the prime tenant's lease, you should allow the tenant to obtain a substitute personal guarantor from its subtenant or from the assignee, someone with similar creditworthiness, somebody with similar assets, to personally guarantee the assignment or personally guarantee the sublease, and potentially get the original personal guarantor out from their personal guarantee, essentially substituting personal guarantors. The tenant's continuing liability, you should counsel the tenant that normally their liability is going to continue under the lease after an assignment or a sublet, although you should try to get a complete release in the event that there is a recapture by the landlord. And profit sharing. Sometimes, I don't know how often we'll see this. I typically see this in slightly larger leases for larger spaces, but sometimes you'll see profit sharing arrangements. And so the landlord's argument is, well, I have you in there as a tenant, and I'm in the business of real estate, you're not in the business of real estate. So to the extent you're going out and subleasing the entire lease premises or a portion of it, you're putting yourself out there in the real estate market, and I should share in the profits that you make from your subtenant to the extent that you're making more than you owe me, the landlord. And so there'll be this profit sharing agreement where I'll let you sublease the space as long as we share, let's say 50% of whatever you make over the rent that you owe me. That's not atypical. And so you may see that. And to the extent that you can't negotiate that away completely, you should make sure that there are some fair considerations for your client. So normally, like I said, it's only for the larger tenants, but if the landlord presses it, then it should be something reasonable, like around 50% of the tenant's rental profit. It's customary. You should push for the tenant's ability to credit its own expenses in obtaining and administrating the assignment or sublease. So if the tenant has costs in rental broker fees or its own attorney's fees for setting up documents for the assignment or the sublease, you should try to get those credited as against any profit sharing obligations that you would have to your landlord. And then you should argue that the profit share amount should be payable to the landlord based upon amounts that the tenant actually receives from the subtenant, rather than the amounts that are payable from the tenant to the tenant from the subtenant. So I'm thinking of the case where you have a subtenant who just stops paying rent, and then the landlord comes back to the tenant and says, "Where's your profit sharing for the month?" The tenant should be able to say, "I haven't actually received it, so I haven't actually incurred any profits to share with you." This is something I heard in a CLE. Somebody said that you should argue that the landlord won't be receiving, to the extent that they want more and more and more share of the profit, and they make this argument that, well, tenant, you're not in the business of real estate, I am. This guy said that, landlord, you won't be receiving any less than the rent that's actually reserved in the prime lease. You'll still be getting that from me at the very least. And also, just because I'm sharing my profits with you doesn't mean that I'm actually sharing my losses with you. So that's kind of a little negotiation tactic. I haven't actually used it. I thought it was a little bit interesting. You can see how that goes if anybody ends up using that line. Also be mindful of the interplay between the sublease and the assignment and the other provisions in the lease. They all still continue to be operating. So be mindful that the assignee or the subtenant is going to be restricted under the permitted use provision, under the certificate of occupancy, under the zoning allowances. They're going to have to get their own insurance coverage under the prime lease, and that they are aware of the end of the term of the prime lease, because the sublease or the assignment, of course, can't extend longer than the term of the primary lease. Paragraph 12, the electrical current, generally utilities we're going to be talking about here. the tenant should be responsible only for its own portion of the building's electricity or utilities usage, and its additional rent under the lease. It's very common for utility charges to be additional rent. As we know from last time, additional rent just means that the landlord can collect it under this term additional rent, so that if it's not paid by the tenant, then they can bring them into landlord-tenant court under a non-payment proceeding. Considerations for the utilities provisions. Does the tenant have a submeter to ensure that it will only be paying for its actual cost of its utilities? And if it's a shared meter, is the apportionment, meaning if it's a meter that's servicing more than one commercial space or more than one area of the building, is the apportionment of the utilities charges in the lease and rider fair to the tenant as against the other tenants? Here's where you're going to want to have a sense of how much water or electricity or other utilities the tenant is going to be using in its own business as compared to the other entities that are sharing the meter. And you should ask yourself and have your tenant, have your client think about whether they have any extraordinary electricity need. Are they a laundromat? Do they have an extraordinary water need? Is the electrical load in the premises sufficient? That's something that the tenant's architect or electrician should be able to advise to the extent that they have one. If they're doing a build out and they're hiring a general contractor or an electrician, that's a question that they should ask if they do have an extraordinary utility need. Let's see. You should ask and see whether the landlord will agree to a rent abatement provision for interruption in electricity or lease termination where the utilities interruption lasts for a specific prolonged period of time. And if not, here we can fall back again on the business interruption insurance to talk with the tenant's broker. Just a note here on reviewing the documents in case that you get a tenant with a dispute about utilities in an existing lease. So unlike water, the electricity bills are not public record and searchable. So if the tenant is concerned about electricity usage in the building at the initiation of the lease before they sign a lease, you may want to ask the landlord for the last several months of the electricity charges or the invoices for the prior tenant at the premises. To the extent that it's a similar business, you can kind of see what the electricity liabilities are month to month. Access to the premises is in paragraph 13. This is a provision that gives the landlord pretty broad authority to enter the premises during the lease term. And the considerations to make here are to try to limit the landlord's unilateral authority to just walk in and do whatever they want while you're in business. What you're going to want to do here is try to get the landlord to give you prior written notice and to limit access only during the tenant's non-business hours or other specified hours that the tenant feels are appropriate. And only while the tenant or the tenant's authorized representative is present. So those should be the only times where the landlord is permitted entry onto the premises. To the extent that the tenant may be more comfortable leaving out one or two of these, but that's usually where I start with to ensure that the tenant has enough notice and can be physically there with the landlord or their representative while they're in there for whatever reason. I would try to also strike a provision that would allow the landlord to renovate or redecorate the premises during the last however many months of the lease. I think that's in the form provision, and sometimes it's missed and it's not amended or rescinded in the rider. There's something in there that says that the landlord can just walk in and kind of redecorate or get the space all ready for showing to prospective tenants or for the next tenant within the last X months of the lease, and that should be crossed out. The tenant is in there, the tenant is paying rent, the tenant should be able to pay to operate their business until the last day of the lease term. Right. Paragraph 15, I'm not going to talk about much, it's the occupancy provision. It's just the belt and suspenders to the permitted use provision and to the as-is provision that we're going to be talking about in a minute. Paragraph 16 is bankruptcy. A lot of this provision is obsolete and just superseded by federal law. This was written at a time when landlords thought that they can kind of get away with anything and everything, but the bankruptcy courts have stepped in and said already, very explicitly, a lot of this stuff is just not enforceable. For example, you can't limit a tenant's ability to petition for bankruptcy. So generally, this provision defines bankruptcy petition as an event of default, and it sets forth ramifications for the tenant entering bankruptcy. Although the tenant may attempt to set conditions or ramifications for the tenant to file bankruptcy, they would likely be superseded by federal bankruptcy law, and the bankruptcy court is generally under no obligation to submit to the bankruptcy-related terms in the contract, in the form lease or rider. For example, like I mentioned, the ipso facto clause in the form lease that says that the landlord may just unilaterally terminate the lease just by the very act of the tenant petitioning for bankruptcy, that specifically has been found to be unenforceable because the leasehold becomes a part of the tenant's bankruptcy estate the second that the tenant files for bankruptcy. And at that point, the bankruptcy court has exclusive jurisdiction over the lease and the lease premises. So contractual provisions generally that seek to restrict a tenant's ability to petition for bankruptcy have been struck down by the court, and I wouldn't necessarily waste a lot of energy and negotiating power here because we already have all of those protections from the federal courts. Yeah.
If a tenant goes into bankruptcy, let's say it's like a hair salon and it has subleases for like the stalls, and one of the subtenants is our client, is their sublease also kind of protected within the bankruptcy? Like it continues through the bankruptcy process?
Yes. Yeah, it does.
Like all the contracts are kind of like standstill as it kind of gets through.
Essentially, yes. The automatic stay is very broad. So the automatic stay insulates the petitioning debtors. Excuse me, insulates the petitioning debtor from both sides. There are potential motions that either party can make to lift the stay for the purposes of terminating the sublease or for terminating the prime lease, but that has to be formally made in the court, and the court has to delve in and opine on that. One interesting note here for bankruptcy is we'll talk again about security and the security deposit section. A security deposit may be clawed back into a tenant's bankruptcy estate. So the second that a tenant files bankruptcy, it gets automatic stay protections under the bankruptcy law, and that protection extends out to whatever security deposit the landlord is holding. So the landlord can't just apply whatever security they're holding to whatever rent they say is owed. It's essentially a stay. It's a freeze on everything, including money that the landlord may have been holding for years and years as security. So that's something good to know, and we'll circle back to later again when we talk about options for giving security. The default provision in paragraph 17 and whatever related default language is going to be in the rider. There will be default lease language in the rider for sure. This is arguably the most important and most consequential provision of the lease. This should be read 2, 3, 4, 5 times to make sure you completely understand everything before you even start to talk about it with your client or negotiate it. Essentially, this provision defines what constitutes a default under the lease, and it sets forth the landlord's procedure for notice, for demanding a cure, and for prematurely terminating the lease based upon failure to comply with the terms. The landlord's legal remedies may accrue based upon the contractual definitions and procedures for an event of default. And they're typically the defaults will fall into one of 2 categories. We have monetary defaults and non-monetary defaults. And these slides are a little bit more wordy just because I think they're very, very important. Under the monetary default, these are the typical procedures, just so you know, and we'll talk more about this next week when we get into the litigation section. So I'm just going to kind of gloss over here. The landlord, when there's a monetary default, will serve whatever day notice, whatever day rent demand is required under the lease with supporting documentation saying, tenant, you haven't paid X amount of dollars in rent or additional rent. The tenant has that number of days to cure the monetary default. And if they don't, before the end of the cure period, then the landlord obtains jurisdiction to serve and file a notice of petition for non-payment proceeding, essentially starting litigation against the tenant in the landlord-tenant court, the commercial part of the civil court. And that could result in a money judgment, and it could also result in a warrant of eviction, evicting the tenant prematurely. When we're talking about a non-monetary default, it's a little bit different. The landlord will also serve an X day notice, depending on what the lease says, to cure. the non-monetary default, together with supporting documentation. The tenant has that number of days to cure or to begin to cure. We'll talk about that as well. And upon the expiration of that amount of time, if the tenant doesn't cure or begin to cure, then the landlord will serve a notice of termination in accordance with the term lease. And then upon expiration of the notice of termination period, the landlord then obtains jurisdiction to serve and file a notice of petition for holdover summary proceeding in the commercial part of the civil court, and that could result in also money judgment or a warrant of eviction. So in the non-monetary default paradigm, the landlord is following a set of procedures to actually terminate the lease. And by the time the notice of termination expires, the lease has expired, and the tenant has become a holdover tenant, which gives the landlord jurisdiction to go into the civil court and ask for an eviction against the holdover tenant, who no longer has any leasehold rights to the premises. I have a little asterisk there in the third point of the non-monetary default. That's the deadline for the tenant to file what's known as a Yellowstone injunction, or to petition for a Yellowstone injunction. You can do that up until the time when the lease is terminated. And we're going to talk about that. Sorry, I think I have another slide on that later on. Yeah, we'll talk about that, and we'll talk about that next week for sure. We'll talk about Yellowstone injunctions. I want to make a quick dichotomy here about conditional limitations and condition subsequents. This is something that even seasoned commercial landlord and tenant lawyers don't really understand all the time, and it can be pretty consequential. It's a little bit of a nuance here, and it's a result of some competing case law and common law. It's kind of an interesting artifact. A conditional limitation, so these are the types of default provisions that will allow the landlord to terminate the lease and get its jurisdiction either in the civil court or in the Supreme Court as an ejectment action. A conditional limitation is a provision that allows the landlord to terminate the lease at its option. So it may or may not include an opportunity for the tenant to cure the default. Right? So the termination that's based upon a conditional limitation does allow the landlord to commence holdover summary proceedings in the landlord-tenant court. That's what they want. The summary proceedings are relatively quick, cheap, efficient way to get the tenant out under a warrant of eviction. Once they're relegated to Supreme Court ejectment action, they're subject to the Supreme Court's timetable of a regular action, which is much longer. It's much more expensive. They have to go through discovery. And so the landlord wants to do everything he can to avoid having to bring a Supreme Court action. So to do that, they're going to want a conditional limitation. And I've written an example of one here. If the tenant shall default in any of its obligations under the lease, then the landlord may serve the tenant with a 10-day notice of termination. And thereupon, at the expiration of 10 days, if the default shall continue, the term under the lease shall expire as fully and completely as if it were. So the option here is for the landlord to call the default, not necessarily to terminate the lease, but having the option to call the default makes it a conditional limitation that then allows the landlord to bring a summary proceeding in civil court. Let's compare that to condition subsequent. Condition subsequent is something that's going to require the landlord to bring an ejectment action in Supreme Court at much more expense. A condition subsequent is a provision that automatically deems the lease terminated upon the occurrence of an event of default, and the landlord's notice is ex post termination. So the landlord is simply just giving notice that the lease has already expired. Right? So for example, the language of a condition subsequent would be if the tenant shall default in any of its obligations under the lease, then the lease shall immediately terminate as fully and completely as if that day were the last day fixed for expiration of the term. All right? And so a lot of the times when you see these, I don't necessarily have good counseling here for you about whether if you see a landlord make a mistake and include a condition subsequent, whether you tip them off to it, because really, if they want to get the tenant out, then they're going to have to go through all the motions of going into Supreme Court. But then again, your client also will have to go through the motions and pay for Supreme Court litigation. This is just really something for you to be aware of. It's kind of more of an academic exercise, and I don't really have any bright ideas one way or the other or the times when you confront a landlord who just doesn't get it right here. If you see a condition subsequent in a rider, there should be some other provision that should like kind of perk up your ears and say that this landlord's not paying attention. So you should look very, very extra carefully through the remainder of the lease provisions in the rider. Negotiation considerations for the default provision. For the cure period, make sure that the default procedure includes a reasonable amount of time for the tenant to cure its default, whether it's monetary or non-monetary. When we're talking about money, typically 15 or 30 days is usual, but do be cautious of chronic non-payment provisions. Typically, these are located separately in a separate provision later on, buried at the end of the rider, and they basically say that a landlord can deem a history of non-payment, for example, 3 or plus times of non-payment in one calendar year. They can deem that a material non-monetary breach of a lease, and that'll give rise to a holdover proceeding. The problem here is it's unclear how to cure a chronic non-payment breach. If you're chronically late in your payment, let's say 3 or 4 times you paid it a little bit late, the landlord can all of a sudden convert that monetary default into a non-monetary default, serve you a notice to cure. It's not really clear from the case law how and if a tenant can cure that default because it's already happened. And so that's going to give rise to litigation. I would try to limit the effect of chronic non-payment provisions by increasing the amount of times that constitute a chronic non-payment, or increasing the period of time in which a landlord can deem a number of non-payments, of late payments, to be chronic. For the non-monetary side, typically I see 30 to 45 days of cure periods. The provision should include language that, with respect to a non-monetary default that cannot be reasonably cured within the 30 to 45 day cure period, that it's simply enough for the tenant to begin curing the default and to proceed diligently with curing the default thereafter. So I'm thinking about a construction, the tenant maybe has to make some kind of repair that requires a permit, and that permit is going to take more than 30 to 45 days to get, simply by bureaucratic or administrative delays. As long as the tenant has begun to cure within the 30 to 45 day period, if they've retained the necessary subcontractor, they filed the necessary permitting applications, that should be enough to have met their obligations under the notice to cure, as long as they continue to also afterwards diligently proceed with curing that default. There's a little portion here on Yellowstone. I'd like to save that until next week when we talk more about litigation. Just one quick point, I would avoid and be mindful of accelerated rent provisions. Once in a while you'll see a provision that says if the tenant defaults, then the landlord can accelerate all of the rent that's due for a certain period of time under the lease. That's kind of archaic. It's very stringent. It's something that we should probably cross out or negotiate down. I don't really see them very often, but they may be remnants in some older form leases, older form riders that some landlords may still be using. What time do we have? 11 o'clock. Do you want to take a quick 5-10 minute break at this point?
Yeah, let's just revisit timing. Yeah, right, because we're supposed to end at 12. People go over a little so that since we started later.
Right.